Hi, everyone, and welcome to S&C Sidebar, where we talk with our different partners about some of the most interesting legal issues they've seen in their careers and what they are seeing on the horizon, among other topics. Today, we are joined by Alex Gross, who is a partner in S&C's litigation group. Alex has worked on high-stakes intellectual property and technology trials and complex commercial disputes in courts across the country. He played a key role on the S&C teams that secured one of the largest patent infringement verdicts ever for Columbia University, turned a defense-side global patent infringement litigation into a $250 million win for our client Ocado, and represented BlackBerry in its successful pursuit of a $1 billion patent license claim against Qualcomm. Alex, usually I start these sidebar podcasts by noting how long you've been a partner, but I think I'm right if I've done the math that you have now been a partner for 22 days. How's it been so far?
It's been an incredible experience.
Great. So why don't you start by telling us some of the most interesting issues you've worked on and all these fascinating cases you've had?
Sure. So as you noted, I worked on a number of trials that involved intellectual property issues and complex technology. And one of the things I find fascinating about that sort of work is taking very complex technology and taking the vast quantities of documents and testimony and information that we obtain throughout the discovery process and distilling all of that down to find what are the golden nuggets that you'll be presenting to a jury. Now, that's true in every trial, but in these complex technology trials, there's an additional layer of trying to explain this incredibly complex technology to a jury comprised of ordinary citizens. And so I find it really fascinating to have to think through those issues and to think through them very early in the case so that as you're going along, you're starting to plan out what is going to be your key evidence, where are you going to find it, and then how are you eventually one day going to tell your story to a jury and explain this very complex technology in a way that they can understand.
Now, at least compared to most S&C litigators, you have a pretty specific practice. How does Sullivan and Cromwell's generalist approach weave into your IP practice?
It's a good question. And I do focus on what I like to call technology litigation. But I also have a very healthy docket of cases and other topics, including M&A litigation, contract disputes, and even some pro bono criminal defense cases. Now, I think that generalist practice and exposure to all these different areas is a crucial advantage that we have, especially in the intellectual property area, where our adversaries at other firms do only intellectual property litigation. And our generalist model and exposure to all of these different areas of law and types of cases allows us to think a bit more broadly and to think a bit more creatively. Perhaps something that you learned or something that you saw in doing a Delaware M&A litigation may actually ultimately be applicable in an IP case. And if you haven't had that experience and if you hadn't worked on those types of cases, you wouldn't necessarily know that there might be some tool out there or a type of argument out there that you could bring to bear to help your clients in IP cases.
Yeah, I couldn't agree with you more. I really do think it's the special sauce. But focusing on your tech litigation practice, any high-level legal developments in this area you think clients should be keeping their eyes on?
Yeah, we've been seeing an increase in the amount of trade secret litigation. There are a number of reasons for this. One is the Federal Trade Commission's ban on non-competes and similar action in the states. And it remains to be seen whether those actually will stick, but that is one reason we are seeing this increase in trade secret litigation. And so it's something that our clients are becoming more interested in as it becomes a bit more prevalent. And we're seeing a lot of really interesting developments in this space. I'll give one, for example. Last year, the Seventh Circuit held that the Federal Defend Trade Secrets Act, which creates a federal cause of action for trade secret misappropriation, applies extraterritorially, meaning that defendants in U.S. litigation could ultimately face exposure for actions of the company or affiliates abroad. Now, that holding has been appealed to the Supreme Court earlier this month, and we expect to see a briefing on that in the coming months, and perhaps a decision from the Supreme Court as early as this year. But that's one area within the trade secret landscape that we're seeing these interesting questions being discussed and being appealed that will have real impacts on parties to these types of litigation. And if I could just give one pitch here, Myself and our partner, Annie Ostrager, will be doing a 4-part series on trade secrets, and in particular, answering types of questions that we think our clients might be interested in hearing. And that should be coming out in the next few weeks.
Oh, that's fun. Let's do a topic switch. In your experience, what has been the most important part of working with clients to develop strong and productive relationships?
So I think one of the most important things to fostering relationships with clients is to really be there for them, both in connection with the litigation and more broadly. And forming these sorts of bonds allows for better communication between clients and their lawyers, and allows lawyers to better anticipate their clients' needs, whether it may be on this litigation or litigation in the future.
Now, I have a important and timely last question for you. What advice do you have for associates who are looking to focus on becoming a partner?
I think one thing that's really important is to take a step back from the day-to-day work. Of course, everyone is expected to do excellent, high-quality work on all of their matters. But I think it's very important to take a step back and think about your career and think about the types of cases that you'd like to work on, the types of issues you'd like to grapple with, and chart a course for how you can do that. I think it's also really important to find your people, the people who do the kind of work that you do, the people who you enjoy working with. And I think doing those two things and demonstrating your value by doing high quality work will put you in a really good position.
Well, it's always fun to spend time with you. I think there's nothing more interesting than hearing perspectives from people at this stage of their career. And I've really enjoyed our conversation. So thank you.
I did as well. Thank you for having me.